What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to break down a motion filed, actually a response filed by the state in Brian Kohberger's case to determine whether or not the defense actually said the knife sheath with Brian Kohberger's DNA was planted at the crime scene. And I'm going to tell you why this is the trial that is potentially most intriguing to me of the entire year of 2025. Yes, that's right. Even with some of the major trials we have coming up, there's just something about this one that I think is going to hit different. And I'll tell you why in the video today. So make sure you guys hit the like button and let's get into it. So we're going to take a look at the state's response to the defendant's motion in limine to exclude the IgG evidence. And just the title of this document gives you an idea that might surprise some of you, because the defense has been making this argument the whole time. They want to fight IgG. It's not reliable. The feds broke the rules. They went and did things that even their own procedure says they shouldn't do. That's something the jury should know about, right? The feds are corrupt. They did things they shouldn't have done. They broke their own rules. Well, during those hearings and during those motions, it was always my thought, and I said this on a couple of videos, and we kind of discussed it, and there was some disagreement in the chat. I think some people felt this way, some people didn't. But this is purely a legal argument. It was always a legal argument by the defense. If they could prove to the judge that something nefarious happened, that the feds violated Brian Kohberger's rights, then a lot of evidence would potentially be the fruit of the poisonous tree. The warrants and different things like that, even though they said this is not dependent on the IgG information, the DNA information that was gotten through IgG, even though the state and law enforcement tried to do everything they could to make sure, even if IgG got struck, it wouldn't necessarily affect a lot of the other evidence they got. But that was always the way the defense was arguing this. Hopefully the judge would be on their side, which he wasn't. And now that he's not, I always felt like this was not a good argument to a jury. It would be confusing. It would highlight the DNA. It would highlight the IgG. Even the state brought up the fact that they're saying, so are they saying it is Brian Kohberger's DNA, but just the way it was tracked, that there's a problem with that? Will they admit to that? What is going on here? And that's actually totally appropriate for the defense. We've talked about it. They can have alternate theories. They can attack different things. They can poke holes in different things. And it all doesn't have to be streamlined because of reasonable doubt. Any of these things on their own can provide a reasonable doubt. It's a not guilty verdict. If their constitutional rights were violated and the court found that way, and you could suppress a bunch of evidence, then it could lead to reasonable doubt, regardless of what the DNA results were. But now that we know the defense did not win over the judge, and the judge is going to allow it to move forward and allow the state to say that Brian Kohberger's touch DNA is on that knife sheath, it seems like the defense may have a new theory. And the state discusses that theory in this motion. The state also discusses and says, am I right to hear that the defense is asking to exclude all of the IgG evidence? So it's incredibly interesting to me how the state breaks this down. We're going to just read the argument part of this motion, which is about 10 pages here, starting on page 6. We're going to look at what the state's argument is. We're going to look at how they battle what the defense says. We're going to discuss what we think the judge is going to do. But most importantly, we're going to listen to how they discuss what the defense's theory is based on an expert, based on some other evidence or testimony that is in a sealed document somewhere, which if they're referencing it here, why is it sealed somewhere else? It seems to be inconsistent at this point. Judge Hippler seems to be for more transparency and unsealing documents. So hopefully that becomes unsealed. Maybe it'll be unsealed by the time you see this video. But let's take a listen. And that's what's going to get us to why this case is so intriguing to me. The defense's motion is based on a mischaracterization of the record and inopposite case law. The state did not act in bad faith. The state never made the concession that the defense now claims. And the defense's reliance on Youngblood is legally erroneous. The defense has failed, both legally and factually, to substantiate a Brady violation. The defense's motion is based on the wrong legal standard. The defense relies on the standard by confusing Brady and Youngblood. The Brady standard asks that the state withheld exculpatory evidence that had a reasonable probability of changing the outcome of the proceeding and applies irrespective of the good faith or bad faith of the prosecution. Brady applies when the state possesses but fails to disclose allegedly exculpatory evidence. And we know in this case, the defense says, we know this exists. The state says, we've given you everything we can. Is the FBI holding something back? We don't know. However, a separate issue arises when the allegedly exculpatory evidence was not withheld by the state, but rather lost or destroyed by the state. In that circumstance, the Youngblood standard asks whether the state acted in bad faith. Idaho's appellate courts have been clear about this distinction for decades. While we have consistently held that Brady applies when the state fails to disclose known exculpatory evidence, and known is in italics there, we have applied Youngblood in cases where the state has failed to preserve material evidence of unknown exculpatory value. The district court failed to distinguish between the state's duty to disclose evidence and the state's duty to preserve evidence, and that Youngblood applies only to situations where the state failed to preserve potentially exculpatory evidence. Determining which legal standard applies is as easy as it sounds. For example, in a case where the state possessed but failed to disclose an allegedly exculpatory social media post, the Idaho Supreme Court held Brady was the correct standard. But in a different case, when the state destroyed or deleted an allegedly exculpatory social media post, the court held that Youngblood applied. Here, Brady applies because the defense alleges that the state failed to disclose Othram's standard operating procedures. Youngblood does not apply because the defense has not alleged the state lost or destroyed Othram's standard operating procedures. Because Brady applies rather than Youngblood, whether the state acted in good faith or bad faith is irrelevant. Thus, the defense's motion, which rests entirely on its faulty accusations of bad faith, fails from the get-go. And this comes down to, what is the defense's purpose for filing these motions? Are they trying to get things out there publicly? Are they trying to pile on and say bad faith? What's the purpose? But we're going to focus on some of the details of this motion. And I think the way it's going to resolve in the judge's decision is going to be kind of an easy guess. Though legally correct, it is unfortunate for the state that Youngblood does not apply because there is no reasonable reading of the record that supports a finding of bad faith. Bad faith is a high bar, requiring more than mere negligence. Rather, bad faith refers to a calculated effort to circumvent the disclosure requirements established in Brady. There was no calculated effort to circumvent Brady. The state disclosed to the court the records it had received regarding the bidding process. Then, just 2 days after learning that the standard operating procedures themselves were inadvertently left out of the material provided for in-camera review, the state notified the defense and the court, still 6 months before the trial. The state acted in good faith, and there's no reasonable basis to conclude otherwise. So eventually they turned it over. The old no harm, no foul, which is frustrating, pisses me off. I wish the state wouldn't do it. I wish the feds wouldn't do it. But generally speaking, if it is turned over 6 months before trial, and again, we can compare this to other cases, and it's really not as bad, still not how it should be, but I think we all know how the judge is going to rule. The defense has not and cannot provide or prove a Brady violation. The defense has not, can't prove it. Related to the Othram's standard operating procedures, there is a true Brady violation. The evidence at issue must be favorable to the accused, either because it's exculpatory or because it is impeaching, that the evidence must have been suppressed by the state, either willfully or inadvertently, and prejudice must be ensued. The defense has not proven any of these three components. First, the defense has not shown that Othram's standard operating procedure are exculpatory or impeaching. Much of the defense's argument is based on misreading of the transcript of May 30th, 2024. To say the state conceded the IGG information is relevant to the case. Of course, relevance is not the proper standard. Explaining Brady only applies when the evidence is favorable to the defense. In any event, the defense is wrong about the state's concession. The defense omitted from its motion the beginning of the state's argument at the hearing, which demonstrates that the state maintained its position that none of the IGG information is relevant to the state's reference to the court's order. We're referring to the in-camera order requiring the state to turn over IGG information to the court, not the disclosure order requiring the state to turn some of the IGG information over to the defense. The state. Thanks, Judge. So I just want to start with maybe a bigger picture for a second. You know, we started with arguments about whether the IGG is relevant at all. We, of course, made our argument that it is not relevant at all. It shouldn't even have to be produced. The court made a ruling on that. We still don't agree with it, but we understand. The court, I understand. The state. The court makes the decisions, and so we complied with the order. In light of that portion of the state's arguments, it is clear that the next portion of the state's argument was nothing more than the state's acknowledging that, to the extent the requested materials exist, those materials fell within the scope of the court's in-camera order, and pursuant to that order, the state had to turn over those materials to the court, not to the defense, is what the state argues. We have talked to Othram. We've spoken to Othram since we have gotten this Exhibit N and provided them these requests. And we are not in a position, for example, Requests 1 through 6, we are not fighting those. I'm not saying we are not going to turn those over. In my view, they fall pretty clearly under the court's order. The issue is we go to Othram and show them these, and Othram says, we have given you everything. You have everything. Everything we have given to the court and then provided to the defense. So there's nothing in this list that we are holding back because we think we have some justification for doing so. Othram is just telling us we don't have it. That the state was referring to the in-camera order and turning over materials to the court is also clear from the orders themselves. The in-camera order required the state to disclose a category of information to the court, all GG information related to this case. The disclosure order, on the other hand, specified precisely which pages or discrete information reviewed in camera needed to be turned over to the defense. Given the nature of the orders, it would make no sense for the state to assert that any additional information not provided in camera would be subject to the disclosure order. The defense's misreading of the transcript pales in comparison to its misreading of the state's motion for protective order. The defense tries to claim the state conceded to its motion that all information related to Othram's work was relevant because the state agreed to provide the lab pursuant to Rule 16b-5. Nothing could be further from the truth. The state dedicated an entire section of the motion to explaining why Rule 16b-5 required only the disclosure of the scientific report and nothing else. This is all, by the way, to give context when the bombshell is dropped about potentially the sheath being planted. The state also affirmatively argues the rest of the IgG information should be protected because it fell outside Rule 16, including any raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as chain of custody forms, laboratory standards, standard operating procedure, analysis notes, etc. Second, the defense has not shown that the state suppressed Othram's standard operating procedure because those documents have been withheld from disclosure to the defendant pursuant to a protective order. Idaho's appellate courts have looked with favor on the use of an in-camera review process for a trial court to determine whether the evidence is exculpatory or impeaching. The court ordered such a process in this case. While Othram's standard operating procedures were inadvertently left out of the material presented to the court, the materials that were provided were sufficient to obtain a ruling from the court that the information Othram provided to ISP as part of the bidding process was not relevant to the case. So that's obviously the defense has beef with. You didn't even provide this. So when the court made its decision, it didn't even know what it was saying with regards to the information you didn't provide to the court. Very annoying. I'm with the defense on this. Incredibly frustrating, but I don't think the court is going to find that the state acted in bad faith. As the state explained in response to the defense's discovery request, Matthew Gamet testified about Othram's protocols and procedures in the context of the bidding process. The documents related to the bidding were included in or referenced in the materials provided to the court to review in camera. The court reviewed the state to discover only the MOU from the bidding documents. The state need only discover pages 99 through 103. The memorandum of understanding, the remaining contract documents are not relevant to any issue in the case. The court did not require the state to produce any of the other bidding documentation, including Othram's bid submission that discussed Othram's accreditation status, other customers, past cases, the name and qualification of the primary genealogist, the name and qualification of the chief scientist, the SOPs or analytical methods that were used, though the SOPs were inadvertently excluded from the materials reviewed in camera. The bidding documentation referencing the SOPs were included, and the court did not require disclosure of that document or the SOPs. So what's annoying is, again, I don't want to get too into the weeds of the state just claiming inadvertent, didn't give this to the court. Court made the decision is incredibly annoying. I wholeheartedly understand why the defense is fighting this tooth and nail. I think they should, although I have a feeling the judge is going to fall on the state's side here. If the defense disagreed with the state's position, it could have filed a motion to have the court rule on the issue. Instead, the defense chose to skip a step and jump straight to alleging the state violated Brady. The defense's only explanation for jumping ahead to the exclusion of the IgG information instead of first asking the court to order the disclosure of the standard operating procedure is a conclusory statement that the defendant would be significantly handicapped by the production of the materials sought at this late date, because with an earlier disclosure, he would have been able to utilize the materials for motion work and consultation with experts. But when the Brady issue is one of delayed disclosure, the question is whether earlier disclosure would have created a reasonable doubt of guilt. Meaning, just because you disclosed it late, is it really creating an exculpatory issue, or is the delay no harm, no foul? That is a consideration in Brady. In Thumb, The Idaho Supreme Court found disclosure of a fingerprint report just 1 week before the trial did not violate Brady because the defense attorney had enough time to review the report and use its conclusions if she sought to do so, and the state then agreed not to use the report in its case in chief. Again, frustrating as can be, but you can see how the courts rule on Brady issues. It's like, oh, well, it wasn't that big of a deal, which again highlights what a big deal it was what happened in the Baldwin case, which happened in the middle of trial. And you can compare this to the other issues we've seen in other cases as well. Here, the defense was procedure 6 months before trial. The defense has not even attempted to articulate with any specificity how the standard operating procedures could make any difference in the jury's determination of guilt, and the state is not seeking to use the standard operating procedure at trial. Third, the defense has not shown prejudice, and the law and logic dictate that the defense cannot show prejudice with respect to Othram's standard operating procedures. Prejudice and materiality are used interchangeably in the context of Brady. When assessing materiality, the question is whether the favorable evidence could reasonably be taken to put the whole case in such a different light as to determine or to undermine confidence in the outcome. Such evidence is material if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Nothing about the IGG in this case, including Othram's standard operating procedure, comes anywhere close to being material for purposes of Brady. It is undisputed that the IGG is simply a means to generate potential leads as to whose DNA found at a crime scene may belong. If one of those leads proves fruitful, the law enforcement can conduct confirmatory testing as to whether the DNA belongs to the suspect using an STR comparison. The strength of the evidence against the defendant in terms of DNA evidence depends upon the confirmatory results from the STR DNA analysis between the defendant's DNA and the DNA recovered from the crime scene. Ruling on the motion to compel production of discovery, the evidence that is material to the defendant's guilt or innocence is the testing that followed the IGG investigation, which directly compared the fresh swab of the defendant's DNA with the DNA profile collected on the victim's nightgown. Here, the IGG information is even less material, if that's possible, than it would be otherwise, because the defense has not disclosed any experts or evidence to challenge the confirmatory STR comparison. Here's where we start to get into the new information. And before we get here, let me answer why this case is so intriguing to me. Everything that gets unsealed, every new document seems to unveil new information about this case that we didn't know before, or a new angle or context or way to look at the information in this case that we have not looked at it that way before. I just saw a video that the 911 call, not just the transcript that we read, but the actual call itself has now been released. I haven't heard it yet in its entirety. I've heard little snippets of it. If you guys get it in its entirety, send it to me. We'll listen to it. We'll break it down. But I will say, as I listen to it, you can definitely hear the frantic nature and the freaking out in the roommate's voice that I heard on the call, which is very different. And you couldn't really hear it when we read the transcript. But when we read the transcript, that's something we didn't have before. So that was new information. And every time there's new information, it just makes me more and more convinced that this is going to be the trial with the most surprises, the most things we don't know as we sit here today, especially when you compare it with Karen Reed and a lot of the other trials where so much is coming out publicly. This case is different. And that's what intrigues me. Are we all going to be like, oh, wow, this is a slam dunk for the state? Or are we going to say, oh, wow, look at the holes in what the state has in their evidence? How could they bring this case? Because I don't think we really know. I think we're scratching the surface on this case. And this is just another example of it, what we're about to read here. And that's what makes it potentially the most intriguing trial of 2025 to me. The defense has disclosed an expert regarding DNA evidence interpretation and the likelihood ratio to challenge one of the state's conclusions concerning DNA. But the defense has not disclosed any experts to challenge the confirmatory STR comparison showing the DNA on the knife sheath matched the defendant's DNA. So is the defense really not going to even challenge that that's Brian Kohberger's DNA? Not that surprising to me, and kind of why all of this seemed like a legal argument to the judge and not something that's really going to work to the jury. But on the contrary, the defense has disclosed that its forensic biology and DNA expert will testify there is good support that Mr. Kohberger's DNA was found on item 1.1, a swab from the knife sheath. Now, I haven't seen this entire report. I highly doubt they're going to be all great and confirmatory to what the state says, but that's a pretty big deal. But instead of challenging the conclusion that the DNA on the knife sheath belonged to the defendant, so the state seems to think the defense is going to agree that's Kohberger's DNA on the knife sheath. But what is the defense's expert going to say? Well, the defense's expert disclosures reveal that the defense plans to argue the DNA on the knife sheath does, of course, it happened right at the crescendo here. The defense's expert disclosure reveals that the defense plans to argue the DNA on the knife sheath does not prove the defendant was ever at the crime scene. And the knife sheath itself could have been planted by the real perpetrator. Let's take a second and break this down. So first, there's a beginning quote. Am I missing the end quote? End quote. Beginning quote to end quote. So that was actually quoted from a page. This is not quoted. And I think I need to point that out because they use words like planted by the real perpetrator. So there's a couple ways to look at this. Now, is the defense going to say it was planted? I don't know. The state seems to think they are based on their expert disclosures. You have to turn over who your expert is, what their credentials are, and what they are going to testify to. So that's what happens in the disclosures so that the state can respond and rebut and get the information they need to fight that if necessary. So if they're going to say that this knife sheath was planted by the real perpetrator, do they mean somebody tried to pin it on Brian Kohberger? Somebody that knew Brian Kohberger got his DNA on the knife sheath? Are they going to say somebody stole Brian Kohberger's knife? Are they going to admit it is his knife and his knife sheath? But the knife is gone because the real perpetrator took it. And they left this behind just to frame Kohberger. How would you have such a perfect crime scene, which again, we don't know all those details, but you leave one thing with DNA on it. And yet nothing connects Kohberger to these victims. Nothing connects it to the car, DNA in the car, et cetera, et cetera. And there's other DNA other places in this case. So the defense is going to be able to string this argument together potentially. Do they have a specific third-party culprit? Do they have somebody that maybe does have a connection to the victims and a connection to Kohberger? Do they have somebody that hates Kohberger and would want to pin this on him? Or is it a random act of violence that they stole Kohberger's knife and they ended up going and committing this crime? Did it just so happen Kohberger was at a store and touched this knife sheath and somebody else touched it and they ended up buying it? How are they going to prove that? Is Brian Kohberger going to testify? This is a brand new detail, a brand new defense angle that we don't know much about. And we don't know exactly how they're going to make this argument. It's incredibly intriguing. I don't think it's a bad argument. I think when you got touch DNA, these are the types of arguments you make. When you've got potential 3 other DNA matches under the fingernails that are inconclusive, or as the defense say, definitely not Brian Kohberger. DNA maybe in a glove, a handrail, whatever. All the things we've heard trickle out. This is going to be the defense's argument, not that it is that on this knife sheath, that it is not too many negatives. They are not going to argue it is not Brian Kohberger's DNA on the knife sheath. That's what the state thinks. Instead, they're going to say, how did that knife sheath actually get there? Because Brian Kohberger didn't put it there. Brand new stuff. Brand new stuff in this case. The parties' theories demonstrate why the IGG work in this case cannot possibly be material under Brady. And again, I think this is actually a good argument by the state to say, after all this, Judge, they fought IGG. They made it a highlight. They publicly argued against it. They wanted these motions open. They are agreeing it is immaterial. It is not important what happened. And now they're trying to eliminate it out in trial so it won't even come in trial. And we agree with them. So how can they possibly win this motion? Which again, that little nugget that was really important for the case is important for this motion. The IGG was conducted as a preliminary assessment of potential owners of the DNA found on the sheath and identified the defendant as a potential owner of the DNA, but it was the scientific process of the STR comparison that confirmed the defendant's DNA matched the DNA on the sheath. Now the state has no plans to use the preliminary assessment of the IGG at trial. The defense has no plans to challenge the confirmatory STR comparison. Thus, the preliminary assessment of the IGG could have no effect on the result of the trial. I think the judge is going to agree with the state's argument here. The defense erroneously asserts prejudice on the basis that it will not be able to use the standard operating procedure to cross-examine the state's expert witness, David Middleman, the CEO of Othram. But the state disclosed Dr. Middleman only as a rebuttal witness to respond to the two IgG experts the defense initially disclosed. Now that the defense has decided not to call their IgG experts, the state has no need to call Dr. Middleman. And if you remember with the case that the state cited earlier, they're not going to call Middleman, just like the state wasn't going to call it when they turned over that fingerprint the day before trial. Pretty good comparison, in my opinion. Now, you're never going to get me to say it's no big deal that they didn't disclose something that I think is important, like standard operating procedures. But at this point, the judge has made his decision. I think it's pretty clear where he's going to go. More importantly, however, demonstrating the prejudice under Brady requires far more than a showing that the standard operating procedures could be used for cross-examination. The defense would have to prove that the cross-examination using the standard operating procedures would have a reasonable probability of changing the outcome of this case. The defense has not and cannot do so. Even if Othram failed to follow every standard operating procedure, that does not change the facts that the IgG merely pointed law enforcement toward the defendant as a potential owner of the DNA, and then they did the STR confirmatory testing. The defendant also whispers in a footnote that the defendant may have been prejudiced because the standard operating procedures could have bolstered the defendant's argument that the IgG work violated his Fourth Amendment rights on the basis that it revealed private medical information. Such speculation is insufficient to prove prejudice under Brady. And I really don't think the court was going to buy it based on the court's decision on the defendant's other arguments. The defense's speculation also runs contrary to all related evidence presented at the hearing. For example, Nowlin, a forensic laboratory manager at ISP, testified the medical information fell outside Othram's scope of work. In this case, that the information Othram provided back to ISP did not contain medical information. Similarly, the defense's own expert who previously oversaw a lab like Othram and played a role like Othram in law enforcement investigations testified such labs develop SNP profiles related to genealogy and ancestry rather than medical information, and developing SNP related to medical information in the context of wouldn't be relevant nor probative nor appropriate. Furthermore, even if the defense's speculation were correct, it would not have changed the outcome of the court's decision. The defense has not proven any elements necessary to show a Brady violation. The court should deny the defense's motion. But the state does not object to the requested relief. How about that? The state and the defense finally agree on something. Even though their factual allegations and legal arguments fell flat, perhaps the most perplexing portion of the defense's motion is the relief requested in the ultimate concession of immateriality. The defense seeks only to the exclusion at trial of the IgG information, even though the state has consistently stated it does not plan to present it to the jury. This means the state finds itself in the unusual position of strongly disagreeing with the rationale for the defense's motion, but having no objection to the defense's requested relief. As the state explained as far back as the beginning of the litigation over the IgG, as recently as its competing motion in limine filed contemporaneously with the defense's motion, the state does not intend to introduce IgG information at trial other than to help the jury understand how the investigation progressed. So we need to get more details on what the other means. Like, what do they exactly mean? The state can do so by referring to the IgG information as a genetic tip without revealing the source or the substance of the tip. An investigator can simply testify that law enforcement received the tip and that based on the information received, law enforcement took the next step in the investigation. So the real question is, does the defense disagree or object to this? And do we need to fight about a motion in limine there? In conclusion, the state did not act in bad faith, and the defense has failed to show the state violated its obligations under Brady. Because you don't want to ever be found to have a Brady violation as the state, even if you agree with the exclusion, and the state handled it well here in this motion. This court should deny the defense's motion to the extent the defense requests sanctions against the state. The parties do seem to agree, however, that the IgG information should not be presented at trial. This court thus should enter an order excluding the IgG information other than, so the other than is, we need to know, does the defense agree with this? Other than as a genetic tip for the purpose of helping the jury understand how the investigation progressed. Signed by Will Thompson and Jeff Nye. It seems like every new motion now, it seems like the veil has been lifted on this case by the judge. Every new motion gives us new information, a new way to look at things, but the real understanding that we don't know what we don't know. And this case seems to really highlight that feeling. So let me know what you guys think. What do you think of that defense? What do you think of planting of the knife sheath? Do you think that's what the defense is going to argue? Do you think it's a strong argument based on the other DNA issues we know exist on this case? And are you surprised that the defense is going to either abandon or just totally go away from the IgG argument and discussion in front of the jury? I think it's the right move, by the way, from the defense. And I said that very, very early on. I think it's the right move, but I want to know what you guys think as lay people. Do you feel like you've understood it? Do you feel like it makes you have a question or a reasonable doubt? Because if it does, that's important. If you as potential jurors see it as a potential reasonable doubt, then maybe it's not smart to abandon it. But you have to realize all the work you guys have done, all the research, all the listening and watching and trying to parse out what these experts are talking about, that would take a lot of work during trial for the defense and the prosecution to do that. And would it become a whole second trial? And would the defense lose that second trial? And now it's just even more of an uphill battle. I want to know what you guys think. Can't wait to read the comments. Make sure you guys hit the like button and are subscribed to our channel. And let me know if you get the 911 call. If you have other questions about other filings in this case, would love to break them down with you. I hope everybody has a wonderful weekend. I'll be on vacation next week. I know we got a lot of read stuff going, so I will try to record stuff or maybe even go last minute live. So make sure you have the reminder bell on. Make sure you follow us on Twitter and Instagram at Tragos Law on Instagram, at Lawyer You Know on Twitter, because we'll be probably going randomly next week when we get some time. The podcast will be dropping Monday, and it's a familiar face that you guys know and love that is coming back on for kind of a part 2 for what we discussed last time. So make sure you guys are following all of us and being in the comments, whether you agree or disagree. Love to hear your questions. Do it respectfully and gracefully. That's the best way to do it. That's what we love to do on this channel. So until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.